Good evening, everybody. My name is Mark Barnico. I'm the Executive Director of the University of Chicago campus here in Hong Kong, Francis and Rose Yuen campus here in Hong Kong. I'm really excited tonight about tonight's program. The title is called Sexual Offense as Fraud Regulation, Fraudulent Sex Criminalization in Asia. I'm excited about it because I'm excited about our speaker, Professor Chen, who I'll introduce in a moment. As always, we're offering this program tonight via Zoom, Facebook, and YouTube. And if you have questions, you can submit them through the Zoom questions and answer button. I also would like to continue to encourage people to sign up for our website at www.uchicago.hk so you can keep in touch with our campus about all the different programs and activities that we have going on here. I'll tell you about a few of them at the very end of the program tonight. So tonight is Nexus Asia again, and Nexus Asia was an idea we came up with a few months ago to feature our UChicago PhD alumni who are actually teaching and doing research in the region, in Asia. And I think we've had about 5 programs so far. We have another 5 yet to go, I believe. But this gives us an opportunity to showcase our PhD alums on our campus and learn and figure out ways, which we were just talking about actually, ways for us to collaborate with other institutions here locally in Hong Kong, throughout the region, and of course with UChicago. We do that through lectures, academic workshops, symposiums, various methods. So we offer this travel grant program for these PhD alumni of ours and kind of facilitate their ability to come to campus, give a lecture, do a workshop. And it's been really exciting to see this whole Nexus program blossom. Tonight we have Professor Jianlin Chen, who's our Nexus scholar. He is a professor and associate dean at the Melbourne Law School, associate dean for international at the Melbourne Law School. He obtained his LLM in 2009 and JSD in 2015 at the University of Chicago. Professor Chen's primary research interests are law and religion and criminal law with a particular focus on fraud through a combination of comparative perspectives and economic analysis. I think he'll be telling you a little bit more about that tonight since we just talked about it in my office. He publishes widely with a monograph from Cambridge University Press and in law journals such as Sydney Law Review, Law and Social Inquiry, Columbia Journal of Law, and then if I don't butcher this, 公司评论, yeah, 北大法论评论. Okay, I got that out. All right. Thank you, Professor Chen, for coming tonight. We'll look forward to your talk.
Thank you, Mark. It's really wonderful to be back because actually, so now I'm in the University of Melbourne. I was there since 2017, but actually from 2011 and 2017, I work really nearby at the University of Hong Kong. So it feels really great to be back in Hong Kong, back in UChicago, to be part of this academic research activity. So today, I'm going to talk about fraudulent sex. What are we talking about here? Basically, we can imagine a few scenarios. The most classic, perhaps, is a man says that he is single when he is in fact married, and then proceed to have sex as a result. Or another more interesting manifestation, which we will soon see is common in the Asia region. Someone, maybe a person, a woman, may have some problems, maybe having difficulty at work, maybe wanting a promotion, maybe have some relationship issue. So the woman looks for supernatural help and find a fortune teller or some religious specialist. The person, the religious specialist, will say that I have supernatural power and yes, I can get your man back, I can get you that promotion, but it will involve a ritual in which the ritual involves sex. So of course, as is the case, this man does not have supernatural power, and you didn't get your promotion, and you didn't get you didn't manage to salvage your relationship. So this is basically what we're talking about. The use of deception, lies, fraud to obtain sex. And the key question is, how does the criminal law in Asia deal with it? So there's two main points which I hope we all can take away from this discussion. So the first, and that is looking at the issue from the criminal law perspective. So when we think about criminal law and how do we deal with the use of fraud to get sex, we usually think about it in the terms of sexual autonomy. We think about to what extent fraud violates or hurts or impute or damage the sexual autonomy of the victim. And then try to figure out, based on this inquiry, at least from the traditional sense, what sort of fraud should be punished as a result. But my argument, looking at the 6 Asian jurisdictions, and the 6 Asian jurisdictions is China, Taiwan, Hong Kong, Singapore, Thailand, and India, is that in all 6 jurisdictions, certain types of fraudulent sex is indeed punished. But if we look at it holistically, we will come to the conclusion that it doesn't seem to be driven by sexual autonomy. Rather, the government, the prosecutor, the courts are more interested in punishing certain type of conduct. So in fact, those sexual offense is used to police speech, to police conduct, rather than to protect, to uphold the sexual autonomy of the victim. Or at least that will be my argument. The second part, the key points is about from the comparative law perspective. So Asia become a very fertile ground for inquiry because of its history. Because of its colonial history, most Asian jurisdictions adopt the law from different European powers. So there are civil law jurisdictions, like in China and Taiwan, which takes their law from the German Civil Code. There will be, of course, the common law from the British colonization, including in Hong Kong. And so because of this colonial heritage, the criminal law in Asia, in particular in sexual offense, differs greatly, not just in terms of the specific provision, but even the overall structure. So the law on the books is very different for sexual offense. But as we shall soon see, we actually see that there are surprising convergence, that in terms of outcome, they are actually surprisingly similar. And so that, of course, brings us, the implication is we have to think more critically about the disconnect between the law on the books and the law in actual practice. So this is the two main key points. But let's start our journey with, of course, Hong Kong. So Hong Kong is a common law jurisdiction. I would say that in comparative research, I will call Hong Kong a living fossil, in that if you want to understand what is the English common law approach towards fraudulent sex criminalization before 2023, you have to look at Hong Kong. Because in 2023, England have a dramatic reform of its criminal law, especially in terms of sexual offense. So it have a very different structure after 2003. But Hong Kong, which by that time have returned to China, didn't, unlike in the past, follow the reform. So in a sense, in Hong Kong, we still see what is the English position for hundreds of years before 2003. So I say a living fossil for us to have a glimpse of what is the English common law position, which for the longest time has been very influential in all its former colonies. So being common law, the key aspect of sexual offense hinge on consent, right? And you can see that for rape, it is defined by sex without consent. So in our inquiry, which is about what sort of fraud to get sex will be criminalized, the key question then is what sort of fraud would vitiate consent? So the common law have come out with, through precedent, have come out with the conclusion that if the fraud is to the nature of the act, that would vitiate consent. Otherwise, it would not be. So to give an example, what it means is that if a man pretends to be a doctor, or maybe it's a doctor, doesn't matter, and tells the patient that, you have a grave illness, I can cure it, but the treatment involves sex. In this scenario, and let's, for argument's sake, and this is of course a factual truth, that there's no treatment which involves sex, right? There's no genuine medical treatment which involves sex. The women will have no remedy for, the man will not be punished for rape. Because under common law, it will say that the victim, the patient, knew that understood the sexual nature of what is going to happen. She knew that she's going to have sex. Now, it is mistaken, deceived as to its purpose. That it's not a medical treatment, it's just for the sexual gratification of the fake doctor. But because she knew that she's going to have sex, she understood the nature of the act, consent is not vitiated. So in reverse, what is the nature of the act type of fraud? It will be the doctor tell the patient that I need to perform a medical examination which involves inserting a medical instrument into your sex organ, but instead of inserting the medical instrument, the fake doctor insert his sexual organ into the patient's sexual organ. So in that scenario, that will be considered fraud as to the nature of the act, and that will be rape. So fairly narrow. Now, there is a separate provision which implicates fraud, and that is impersonating her husband, spousal impersonation. So there's a very nice historical backdrop, but I don't want to touch on it too much, but just to know that this provision is informed again by common law courts interpreting, have carved out an exception, but it also has been reflected in statute. So for rape, the type of fraud which will vitiate consent will be quite narrow. It certainly won't cover the scenario I talk about, including the case of the supernatural, because in those instances, the victim clearly knew they are going to have sex. But, and this is similar to the UK before 2003, there is, in a sense, a saving grace in the English common law approach. There is Section 120, which says that a person who procures another by false pretense to do an unlawful sexual act in Hong Kong or elsewhere shall be guilty of an offense. So here we can see that basically if you use, under Section 120, if there's any false pretense or false representation to get sex, it will be a crime. So this technically, and the courts have often referred to this in justifying why only nature of the act will be punishable as rape. It says that rape is a serious offense. If it's all other fraud, please use the lesser offense. So the courts recognize that this is a supplementary offense. Now, I know there's a few things which is jarring. More importantly is unlawful sexual act. Again, history. The historical backdrop is that any sex outside of marriage is unlawful, and every sex inside marriage is lawful. So those are the dark ages in which marital rape is not a criminal offense. Now, of course, over time, that's not the case. And even though the provision still maintain the wording of unlawful act, the Hong Kong courts has been clear that this doesn't mean anything now. We have interpreted in modern circumstances. So it covers all forms of sexual act within marriage or not. But there is a bit of history behind that unlawful sexual act. All right, so this is Hong Kong, common law, but English common law, and you will find similar structure in Australia as well. So then we go into India. Also a former British colony, but its criminal law is very different, mainly because of codification. So again, fascinating history. Now, when we look at the world now, we will assume that from the legal point of view, common law reigns supreme, mainly because Britain and now United States have been dominant on the geopolitical stage. And people usually associate dominance, the law of the dominant power, as good law. Not accurate and scientific by any means, but that's human nature. But what is interesting is in the mid-19th century, where India is coming up with a criminal law, it was a time where the British legal scholars actually look to continental Europe with envy. They feel that the common law, which is all based on judges making law, those are haphazard, almost barbaric, but certainly backward. It is the continental with their carefully, scientifically, logically deduced code, which is the shining example of lawmaking. So actually in Britain, there is a huge push to codify law as with the continental Europe. But as with any law reform, vested interests will always defeat good legislative reform. Because if I'm a lawyer who make my living figuring out the law by looking at all the casebook, why do I want to change to a law in which theoretically a layperson would actually know what the law is, right? And that is the appeal of a code, right? You know the law by just looking at the code, not some dusty old casebook to find out the precedent. You can just get the law, all your law in the code. So there will be huge reform. So it's only in the colony where there's no vested interest, right, in India, in which the codification project managed to take hold. So the reformer do come out with a code which is actually meant for England, and there was good pressure. There were people who actually want to have it, but in the end, vested interest step in. So we can only see it in India. So one of the key things about the code is that it put together all the criminal provisions into one single statute book. And so it is able to, for example, use a single set of definition for every other provision. So naturally, given that consent is an important aspect in all aspects of criminal law, in fact, consent is what distinguishes a taking of property, whether is it a borrowing or is it theft. It all actually depends on the consent of the property owner, right? So consent is a big thing. So there is within the code a specific provision which talks about consent. And it says that a consent is not a consent for any part of this code if it is procured or obtained under a misconception of fact. So technically speaking, any type of fraud would vitiate consent. And then when we come to the rape provision, and it will have, I'll put it out, it will mention that like in the English, when we look at Hong Kong, it will mention that without consent, that will be rape. So immediately here, you will realize something radical. With Section 90 plus without her consent, then technically speaking, all fraudulent sex is now rape, right, from the provision. But of course, the thing is a bit more complicated, mainly because there's first, secondly, and then there's fourthly, right? That where with her consent, and then this basically she believed that he's another man who is lawfully married. So basically, spousal impersonation. So the provision itself, there is a bit of tension and actually bad drafting. So a bit of a query as to how would consent for the second part be actually interpreted. But at least one possible interpretation is to apply Section 90 to this directly and finds that all forms of fraud will result in consent, or result in rape. All right. So we see the common law, right? Two manifestations of the common law. And let's go to civil law. So let's start with Taiwan. So if Hong Kong is the living fossor for the English common law position, Taiwan is the living fossor for the German provision. So German have a major reform in 2016. So now it looks very different. But before that 2016, the basic structure and wording can be found right now in Taiwan. So unlike common law, which premise the sexual offense on consent, the civil law system focuses on the offending conduct. So there is a provision, and that is Section 221, which focuses on, you can see, force, threat, intimidation, right? Basically emphasizing the physical violence aspect of the crime and punishing it as rape, the most serious offense. But then it has another provision to deal with offending conduct which doesn't amount to physical violence or threat. So for example, there's a separate provision about a person who takes advantage of someone who is in a condition which makes resistance impossible. There is the take advantage of abuse of authority, 228, and a specific provision of fraud, again, spousal impersonation. Okay, so by now you keep asking, why spousal impersonation can come out? And it feels like, how? Now, there's two dimensions. First, the more proper historical account. 150 years ago, men often have to go abroad to trade, to fight war, and may come back a year, years, maybe physically disfigured. There is a real chance that there could be a mistaken identity. So there's that. But having said that, spousal impersonation of intimate partners actually still happen in current days. I can talk more. Some of them is just bizarre and funny. It's a bit funny, actually. I mean, they're sexual offense, but it still happens, right? So, but anyway, for the law itself, what we see is the German civil law doesn't look at consent. It focuses on offending conduct, delineating specific provision for specific conduct. And we can see that there is one for fraud, which is very narrowly defined. So in a nutshell, we will feel that, okay, basically the type of conduct we described earlier probably would not fall under because fraud is not mentioned. And then finally, we look into China, which is itself ostensibly based on the German civil law, the Japanese law, and of course the Taiwan as the predecessor of the People's Republic of China. And it looks very similar, right? Violence, coercion, there is a catch-all provision, but if we interpret it, we probably want to interpret in violence and coercion. But one of the key difference between China and Taiwan is that Taiwan, as you remember, the German civil law have a whole set, right? There's this forced violence provision, and then we are supposed to see abuse of authority, take advantage of condition, inability to resist. But in the case of China, that's it. Just this one provision to rule everything, right? And so there are many comparative scholars who look at this provision in China and come to the conclusion that China have a very regressive sexual offense law because you need violence, intimidation, coercion before it is any sexual offense, right? Because there's no even a saving grace of other sexual offense in the case of Taiwan. In China, it is violent coercion or any other means. So basically, if it's not force, there's no sexual offense. So scholars have actually written on the basis. So at this place, take a quick stock. I hope you can see that the law in Asia is indeed very different. reflecting the different colonial or foreign influence. The structure is very different. The wording is very different, right? But what about in practice? So now let's look at Hong Kong again here. And I think first, how many of you are surprised to know that if you use fraud to get sex, it's actually a crime? If you tell your girlfriend that you love her and while you're not, or you are, I'm not seeing anyone when you are, that technically speaking is a crime. Exactly, but that's not what we think the law is, right? So I look at a 10-year period. I try to figure out as many of the cases as possible. I've got 15. And what is particularly interesting is the vast majority. The vast majority is on religious fraud, which is itself striking, right? It can be used to punish so many things, like Tinder dates. Like how many of people fake their profile on Tinder? And yet, those are not prosecuted. Prosecuted is religious fraud, which itself is even strange in the context of Hong Kong. Because how is the courts going to determine it is fraud in the first place? Isn't there supposed to be religious freedom, right? In which the government is not supposed to determine whether a religious claim is true or false. So if you're going to prosecute someone for religious fraud, it's not just selective, it's interesting in terms of the selection of it. For the case of Hong Kong, there's the issue of, is there some religious freedom violation behind it? But never mind, we see that in the case of Hong Kong, a provision which can punish everything is only used to punish, for the vast majority, a very specific subset of fraud. Then we look at India, misconception of fact. So the courts actually, in applying the rape provision to fraudulent sex, look at Section 90 and just says, yep, it's misconception of fact, that's it. There's no limitation to it. And so if I look here, because it's a bigger nation, I look at 5 here, I managed to find 41 reported cases. Oh, sorry, the religious fraud is a typo, right? It's 40 of them are false promises of marriage. Basically, a man saying that I'm single, I love you, I'm going to marry you. In fact, next weekend, I'm going to your parents, I'm going to bring the betrothal gift. We're going to get married, but tonight, let's do it first, right? And after tonight, the marriage didn't happen and go to court. Those cases end up to be prosecuted, and they actually result in rape conviction. And in fact, what is interesting is last year, the 5-year cases, the survey is before last year. It was, the cutoff date was 2022. Last year, there was a new provision which itself, I think, reflect the reality that it explicitly says that, yes, you are not supposed to make promise to marry someone, right? It is to get sex, that is something to be punished. So what we see is that in Hong Kong and India, you can punish everyone, at least based on law in the books, but in fact, not every type of fraudster to get sex is punished. So now then let's look at the civil law, right? Let's start with China, right? Violence, coercion, or any other means, where if your basic legal interpretation, you will say that, yes, there is any other means, but it should be similar in concept as violence and coercion. But again, we see that if I look at over 5 years, a 5-year case study, we see that 3 types of fraud, which clearly doesn't involve violence and coercion, all result in conviction. So there's religious fraud, the supernatural type I mentioned. There's medical fraud, doctors or fake doctors claiming that sex is part of medical treatment, and the impersonation of intimate partners. Some of it includes a typical bait and switch. So two persons agree for a one-night stand, but the man, after leading the girl into the room, a darkened room, leave and let his friend take his place. So that is some of the cases of impersonation of intimate partner. So clearly no violence and coercion, but the courts, the China courts, take a very expensive view and punish all these three as rape. And then we look at Taiwan. So Taiwan, again, we have 221, force, threat, intimidation, hypnosis of all or other means. How does the courts try to apply to the supernatural cases? Well, the court come out with an interpretation. It stressed that, so the courts do recognize that this is a German civil law. It has to interpret other means against the person's will by looking at what is in front. So it says that I will focus on the psychological helplessness, which actually is fair, right? Psychological helplessness, vulnerability, seems like a bit of coercion, perhaps. But then it's interesting, it adds an important caveat, is that, and the defendant used method which is not verifiable by science, singling it out, right? Because this itself is important in that, first, in the case itself, the victim, the defrauded victim, is, I would say, not in a position where one would usually associate it as typical of a state of psychological helplessness. These are all working adults. One of them is saying that they have trouble with their boyfriend. The other doesn't have a good boss. The boss is being difficult. And this is the type of real life problem they are facing. So not those like, oh, a woman stuck in a domestic violence relationship but couldn't leave because of children and the fact that the husband is the sole breadwinner. Not those, not the case of I need to work because there's a lot of debt in the family. If I quit the job, I can't, family can't pay the debt or can't pay the medical bill. Seemingly trivial. But of course, that itself is not damning per se, because if the courts wanted to take a broad approach towards psychological helplessness, maybe that's good on the sexual autonomy front. But then we see what happened if the defendant does not use means, or rather, if the defendant use means which are verifiable by science. So in another case in the same year, we are looking at a victim who is 12 years old, who is mildly intellectually disabled, but the court says, no, this is not rape because the sex was induced by the false claim of giving this person money so that she can buy clothes. The court says, oh, no, this is not a sufficient violation against the person's will to constitute rape, right? But you can see the disconnect, right? You can see that the courts here is very concerned. On first hand, it feels like the concern for psychological helplessness is defensible. But when you see how they apply, how they single out not verifiable by science, you find to feel that the story is very different, especially when you see that in other type of fraud scenario, the courts are not prepared to use the rape charges. So where does it lead us? So back to criminal law, right? So I hope we can at least start to see that sexual autonomy is really not what is happening. If we care about, if we believe, if we take the stance that a person's sexual autonomy is violated by fraud, then it doesn't make sense to be selective in terms of the type of fraud which is being punished, right? But if you think about in Hong Kong, where they are only punishing religious fraud with a provision which is supposed to punish everything, or look at in Taiwan, where a provision which is not supposed to punish fraud, it was specifically expanded to punish fraud, but only of a certain type, only on a type which is by methods unverifiable by science. My argument is actually what the courts are doing in all these places, insofar as they are dealing with religion, religious fraud, is they are actually regulating religion. So to them, the sin committed by the defendant is not violating women's sexual autonomy, but rather defiling religion. In fact, in both the Hong Kong cases and the Taiwan judgment, there are explicit pronouncement by the courts in which they allude to the harm to religion, right? Which itself, I think, tell the whole story. And of course, then we look at India. So India case require a bit more explanation, but I would say that it is a form of maintaining sexual orthodoxy. And that is, I think the idea is that women is not supposed to have sex outside of marriage. So if you are deceived and have sex, it's your problem, right? But if you are deceived because you think that the man is going to marry you, okay, you're not the worst type of victim out there, so the law will still try to step in and help you, right? So that is my argument to explain India. But in any event, think about what a false promise of marriage is in terms of fraud. It is actually a very expensive view. It's basically, as long as it's a promise, right, but the person doesn't have any intention to fulfill it, that is sufficient to constitute rape. So it's actually a very liberal approach in terms conceptually about the type of fraud which can vitiate consent, but only if it involves marriage, right? So it's not, again, prima facie about fraud violation of sexual autonomy. And of course, if you're talking about India, any suggestion that the courts are super invested in upholding women's sexual autonomy probably require a lot more justification and defending than humanly possible. All right, and finally, we do see that medical profession come into play, but I think that can be explained that it is to safeguard the medical profession, to make sure in the medical treatment, when the public go to seek treatment, therapeutic treatment, they can trust the doctor, can trust the advice. So it is about protecting medical profession. So that is the criminal law aspect. Sorry, you want? Okay, sure, not a problem, right? And then we look at the comparative law, right? The convergence. The convergence in outcome. We see that certain type of fraud actually got a bit of attention in Asia, religious fraud in particular, right? And this is amidst that divergence in legal provisions, that the provision, the structure, the wording is so different, and yet they can all reach the same place. So the key implication, of course, a bit from a Chicago point of view, which is usually adopt a realist point of view, of course, to say that there's a disconnect between law on the books and actual practice, that itself is, in a sense, not groundbreaking. Still, there's still certain things worth picking up. And I think one aspect is how we think about civil law jurisdiction. Because when we think about common law jurisdiction, any legal researcher doing common law research will always know that after looking at the statute, you must look at the cases, because court cases are binding precedent. They may have new understanding, new interpretation, which can transform the law. So any legal scholar looking at the common law jurisdiction, researching it, will always know to look at cases. But the same scholar, literally the same scholar, when look at civil law, in fact, reflecting the common perception is that civil law, because they are code, the judges don't make law. They just applied it. So the law itself will reflect the reality, the legal reality. But what we can see here is, just like in the common law, the civil law judges can be very creative, can adopt transformative interpretation of the law, which will make the actual legal outcome very different from what you would imagine from ordinary reading of the statute. And I think that is worth remembering when we do research, especially in a comparative sense. But of course, more importantly, from the case study, we also start to see that law may have limited impact to counteract strong public sentiment. In sexual offense, this is actually, again, not new. So there is a literature known as the rape myth, there's a literature on rape myth, which is that actually in most Western countries, the rape law have moved away from simply accepting that rape is caused by force and physical violence. In fact, not most, all the Western country, the sexual offense law will basically say that if you say no, if you do not want to have sex, that is rape. And so it can happen within friends, it can happen within familiar people. But the rape myth literature, through empirical work in court, finds that in actual practice, many of the legal actors, the prosecutor, the judges, the jury, still imagine rape in the traditional sense, that it is a stranger lurking in the shadow, pounce forward, use physical force, there's resistance, there's injury, and that is the real rape. So it's called rape myth because that is not what the law says. That is a myth, right? This is no longer the law. It was in the past, yes, but it's no longer now. And so this is the literature which looks at it. So what we see is that in the case of fraud and sex, it's the same thing. There's still this persistent idea in society, notwithstanding the provisions on the book, that it is okay, and it's usually men, for men to use fraud to get sex. And here, let me jump a bit to Australia. So it's not part of this book which I'm writing, but it's actually, I've done work in Australia because I'm in Melbourne. Always do local, right? We must eat local, do local. All right. And so there, one may argue, when I argue that the impact of the law is limited, to say is that, hey, in Hong Kong, those laws are imported, transplanted by a non-democratic process, by a colonial master. So yeah, the fact that it's not being internalized, big deal, right? But in Australia, in only the past 30, 40 years, many states have actually made legislative reform, progressive legislative reform, where they have a legislative statutory definition of consent, and which is very clear in some states that any fraud would vitiate consent, which means that all forms of fraudulent sex is technically rape. And this is by a democratic process fairly recently, 30, 40 years ago, right? Not some pre-World War II era, right? It is a very recent process. But what is the impact on societal understanding? So I actually did a research where I basically cross-referenced the university sexual misconduct policy to see, all Australian universities have sexual misconduct education and policy on websites telling students about all the things they shouldn't do or all the things which will constitute sexual misconduct. And my role is simple. My role as a researcher is just to see to what extent the university website and policy reflect the law of their states. Do they accurately tell the students, the staff, that the state's law is one where any form of fraud would have constituted rape? Surprise! 50% underreport the extent to which fraud is a rape in their sexual misconduct. Can you imagine that? Right, the university, when they are deliberately trying to design a website educating its staff and students of sexual misconduct, either didn't look at the law or look at the law but somehow do not see the provision that all fraud will vitiate sexual consent, and spread the continuation of the outdated patriarchal norm that fraud is part of seduction, nothing to see here, right? But what we see in Asia, connecting with what is happening in the West, really reflect that legal change. When law is trying to transform societal attitude, we must never be optimistic about its impact because society have many ways to push back against it. And finally, okay, the conversion online. It's a bit too technical, so I'll leave it. So that is my presentation. So is there any question and answer?
Do I need the microphone or am I loud
because
enough?
I think the Zoom so they can hear more clearly.
Hey, I run a charity that works on child sexual abuse prevention, so I'm mostly not here for myself, although this is fascinating. I'm here on behalf of Rain Lily, who is our local sexual violence crisis center dealing with women of all ages.
Yeah.
I have a couple of questions about how to interpret fraud in the best legal sense. And I'm sorry, I won't be able to remember the names of the cases, but you probably heard of them recently. They just happen to be two cases about trans identity. One of them, I think, is in the UK.
Yes.
A trans female did not disclose, a post-op trans female did not disclose her sexual history, but was convicted of rape.
Yeah.
The other is a cis man who was advertising himself for dating on a lesbian dating platform and described himself as a tomboy and did literally rape a female and was not convicted because he said he genuinely misunderstood what website. I just wonder if you have any comments on how to compare those two types of fraud, and are they fraud?
All right. So the legal definition of fraud is one where if the representation is material, is something which the victim cares about, but it turns out to be false, then it is going to be rape. Now, there's a bit of a ministerial requirement, and that is, and this is, I think, explained in the later case. The later case is not a case that it's not fraud, but the defendant may not know it is fraud, right? But of course, you are skeptical, and I think you're right, because I think my personal view of this sort of convictions, these prosecutions on transgender is the problem is that of its selective nature. Okay, as a disclosure, in my academic writing, I never really talk about what I think the law should be because I feel that it's value driven. But my personal view is that any fraud which would be a crime if used to get money should be a crime if used to get sex, because there's no reason why sexual autonomy is less important than property interest. And by having parity, we can just draw on everything we have used in traditional fraud, all the rules to decide what sort of fraud is too trivial, what is simply a bit of exaggerated advertising. We have all these case laws and experience. We can just apply with the sex. So that's my personal view. So on the individual basis, I have no problem, of course, to say that lying about your transgender history, medical history, would be, or rather not disclosing or being misleading about it will constitute rape. So prima facie, in an isolated instance, I don't have a problem. But I do have a problem in the actual prosecution because it's clear that what has happened in the UK is not, again, a general concern about the sexual autonomy of women. They are really just having problem with transgender people. They are really, the prosecution is driven by basically saying that, oh, we want to protect this heteronormative space and we do not want all these weird people to infringe on it. And so if you try to do it, we will police it actively and make sure you are keep a straight line. But if there's any other fraud in other settings, nothing to see here. So that's my problem. So if you say that if there's these cases being prosecuted, but all other type of fraudulent sex is also prosecuted, I would say, okay, that's a new norm. We should just not tell lie. But in the case of the actual case in the UK, what I detect, and many scholars have indeed detected, that they are driven by transphobia, and that itself, I think, is problematic.
When you look at these things, you're giving a nice theoretical thing about charging people, say, for fraud, but in reality, and I have a little bit of experience with this kind of thing, is that what you're stuck with is sort of he said, she said, and so you know, who do you believe? If did he say he was going to marry her in the morning or whenever, or you know, or did he say it directly, or did she just infer that, and perhaps the inference wasn't there? Or if he just says, "No, I never said that," and she said, "Yes, he did say that," how on earth can you go there? So these are actually could be one of the reasons why there's some other odd-looking prosecutions, because it's just so difficult to actually come up with the evidence of that kind of thing.
No, excellent point. And I think evidential issue is always a big issue in sexual offense. But again, the problem is that it is not consistently applied. So for example, in property fraud, same issue. You go to buy a house, you go to try to buy a house through an agent, or you go and buy something through some direct salesperson. Again, they will make a lot of promise, and then there is the, is it binding? Correct. So
the bedroom, there's generally not so many witnesses.
correct. Yeah. But the key is that whether that first for property offenses, similar problem exists, and the law will just manage it. Where there's insufficient evidence and many of the consumer fraud is not prosecuted because of the lack of evidence, because it's verbal, it is what it is. But the more interesting question is, there are many examples where there is more than enough documentary evidence. So Tinder fraud. On Tinder, you put your profile, says that I'm a single rich person, when I'm in fact a married poor guy, right? And the communication, which is all written, it says that, you know, the women may actively say that I definitely do not want to be a third party. I do not want to be a home wrecker. It could easily establish the fact that the woman is looking for marriage, is not looking for someone who is already attached or otherwise, or is looking for money. So it's true. So if we're looking at a situation where there's issue with evidence, there shouldn't be prosecution. That's true for property crime as with sexual offense. But there are plenty of sexual offense involving fraud in which documentary evidence is not an issue, but like Tinder fraud, right? How many of the Tinder profile is actually real, right? But in Hong Kong, they are supposed to be punishable, but have any of the women or a man actually think about suing, right? So there's this interesting thing is the state will laugh at it, but of course, even the people didn't understand that the law actually, it is a criminal offense. But that, of course, is the same with Australia, right? They have the law, but even the Australian university is not prepared to tell the student what the real extent of the law. So I think that is a bigger problem.
Are there any questions online from anyone? I'm soliciting questions from online. So anybody that has them, send them in on Zoom, and Sandy will make sure I see them. Any other questions?
You could ask another one
You absolutely go right ahead.
Okay.
Right. You talk about the religious fraud. It reminded me of Sue Tim Tim. Do you remember Sue Tim Tim? She was the woman who ran Chinachem, and then there was the religious guy who was doing all the feng shui stuff, and he basically took all the money from Chinachem, and so then the family then hit back to using all this stuff about religious fraud to try and get the money back. So, I mean, that's sort of goes along in a way with what you're saying about, you know, society and they're not protecting the woman as such. You know, they're protecting society and the money, the family money, basically. And he ended up in prison, I believe, for kind of sexual fraud because he got all the money out of her. Well, maybe that's what it was, and maybe it wasn't. But that's the way it was really pushed.
No, I think that's a good point. So just as a plug, but next Thursday, I'm actually in Hong Kong U talking about law and religious, the regulation of religious fraud in China, Taiwan, Hong Kong. But so 2 points. So first, many of the monetary fraud involving religion is actually not religious fraud. It is basically simple accounting fraud. There's a charity, there's money there, you embezzle it. So it's actually kind of boring from a legal point of view because it's just basic embezzlement or accounting. But what you are saying is also right, is that in other instances, when the person involved use religious pretense to have sex, the state would suddenly much more likely feels that some form of fraud is encountered, because it's quite embedded in China, Taiwan, and Hong Kong that any involvement of sex in religion is automatic indication that it is a religious fraud. Now that, in the case of Taiwan and Hong Kong, is actually against their constitutional protection of religious freedom. Not for China. China's constitution is actually quite clear that the state can make that determination. But in Taiwan and Hong Kong, it's not supposed to be. So that's the fascinating thing, that there is a constitution which says what religious freedom is supposed to be, but in actual practice, people will look at things in a very distinct way.
As you probably know, Hong Kong is and has been for nearly 20 years in the process of reforming our sexual offense laws. The Security Bureau has almost promised that they'll do it later this year or next year. So we're all working very hard to write our recommendations, and hopefully there will be a public consultation by January or so. We are spending a lot of time revising what we recommend for the actual definition of consent. Do you have any comments on how we might marry the concepts of fraud, consent, and coercion or other kinds of already established fraudulent behaviors?
Okay, good. So good. In that case, actually, let me bring you to Singapore, which I didn't touch on but I want to have a Q&A. So Singapore is interesting because of how not to do legal reform. But it get it right in the end. So I'm from Singapore, so I'm still going to say to get it right. So before 2007, it has basically the Indian Penal Code manifestation, right? This look exactly like what we see for India, right? That's pre-2007. Now, remember what I said about Hong Kong being the living fossil for pre-2003? So 2007 was important. It means that England, the motherland, even though it's independent for the longest time, has reformed its sexual offense provision in 2003. So Singapore decided to do something about it. And this is what they did. There's the consent, right? So exactly the same. After 2007, it basically removed all this C, D, E, and A and just make rape simply sex without her consent, with the same misconception of fact definition. So what it means is that after the reform in 2007, anyone looking at the law in Singapore will really feel that any form of rape any use of fraud to get sex will be rape, right? And the reason is because Singapore look at the English reform that feels that all those others, it feels that it's just to be only about consent. So it make that jump, but it didn't realize that it actually is in the Indian Penal Code system. Everything is actually dictated by Section 90, which is not the British experience, not the English experience. So the reason why the English didn't do it a certain way is because there's no Section 90. So Singapore ignore it. But of course, the truth is Singapore is not prepared to a position in which all form of fraud. So finally, after 2020, it finally get it in the right place. So it insert a new section, which basically says that notwithstanding the Section 90, which basically says that all misconception of fact will vitiate consent, is spelled out that 3 types of scenario would constitute rape. Nature, purpose, so a bit of extension, but not too many, sufficient to catch the medical treatment case I discussed earlier, and the identity. So it'll say that this 3 is rape. And then it further goes and says that, but we also know, based on experience, that there are many other type of fraud which doesn't fall into all these 3, and it have a specific provision, right? Not the type in Hong Kong, which is basically all fraud, but it says that first, sexually protective measure. So this is actually you probably may be aware, is stealthing. So the man promised to use a condom during sex, but secretly remove it. So is it rape? Is it without consent? Big cases. So the court says that Singapore feels like, I don't want to put it as rape, right? Because it's not nature, purpose, or identity, but it clearly should be an offense. So it singled it out to say that if it's sexually protective measure, it will be an offense because it feels that people have been talking about it. Another is sexually transmitted disease. Again, in Canada, there is cases where the man has HIV, but did not disclose to the partner. Is it going to be an offense? And the Singapore reactor says that, yeah, this is, again, it doesn't constitute rape because it's not nature, purpose, or identity, but it put it in. So basically what the Singapore government is doing is that it identifies first what clearly are serious fraud, which should be punished as rape, and there is a nature, purpose, identity. And then it have a separate provision where it just come out to say that these are the things which we want to punish as an offense, right? And so one of the interesting implications is the issue of transgender actually is not going to be punished in Singapore, right? Because the courts have a nice parameter to work with under this. No, don't worry. The identity clause, they are clear. It's not the it's not your case, everything is like you being you, right? So the identity, they make a distinction between identity and attribute. So that's not an issue. So don't worry. So, but that actually helps, right? So I think for the case of Hong Kong is you just have to own it. You cannot pretend to be progressive, to say that all fraud, don't want to limit it, when in fact, both the legislature and the society is not prepared to accept it, right? You don't have a case of what happened in Australia University, where the law goes so far, but clearly it is not reflected in societal attitude. And what it does is it challenged the legitimacy of the law itself because it put the law in disrepute, that the law is not properly enforced. It's better to be honest that if we're not ready, let's take it slowly. But yes, question. Right?
I have a question about the fraudster under the supernatural. Can you talk more about that? Because what if the fraudster says something like, I'm going to do my best. There's a chance that this cannot happen. So the victim or the customer at that moment agrees to something that doesn't have a 100% chance. So how does the court treat that?
Okay. Unfortunately, this is a hypothetical. All the religious person there are very confident in their supernatural power. But I agree, if proper caveat is given, then of course there's no case because there's no fraud, right? It's the same thing as, I suppose if we think about property fraud, if we sell a health food, if we say that this thing may help, right? But no guarantee, it do depend on your personal circumstances and your exercising habit with all the caveat, then probably there's no consumer fraud in terms of selling that health food. But if the salesperson says, this will cure your cancer, right? Don't worry, you eat this for 1 month, your cancer is gone, that is fraud. So if hypothetically there is such a self-conscious religious person, it will not be fraud. And then actually, to be honest, it's the right way to do religion. But that is actually, you're actually right, that's just not fraud. But the key is, when people start talking about supernatural power, they go all in. There's no like middle way when you say you have supernatural. Either you have it or you don't. So unfortunately, the cases doesn't reflect that. But I would imagine if it really do happen, there will be no case. And I think more importantly, the victim will not feel deceived, right? Because the victim understand that it's just a process.
There are no questions online. Are there any other questions in the house? You have a question? No? All right. Well, thank you so much, Professor Chen. That was really a dynamic presentation, and I think many of us probably look forward to reading your book when it comes out. When will it be out? Would you say Singapore is the best example of the kind of law that?
Finally, after making a mess for twice, the third time it got it right. Yes.
Okay, all right. Well, thank you so much.
Thank you.
I'll just go ahead and close us out real quick. Just a couple reminders. September 25th at 6:30 p.m., we have another Nexus. Professor Ankur Sarin of the Indian Institute of Management in Ahmedabad. I'm struggling with my words tonight. He'll host a talk, Private Schools as Instruments of Choice and Equity. This is our first Nexus professor who will be coming here from India, which I'm really excited about. So I hope you can join for that. I'm also really excited about next Friday night, a week from tomorrow. We have our UChicago men's and women's basketball teams coming to Hong Kong. That program will be September 19th at 6:30 p.m. And we're hosting a panel discussion, what it's like to be a student athlete at UChicago. People have asked whether children can attend, and I have said it should be a very fun event. So if you want to bring your kids, I'm okay with that. So yeah, we'll have a panel and a reception. The coaches and students will be on the panel to discuss how athletes juggle between academics and athletics. Don't forget to sign up for our e-news on our website. And just for all of you, some of you are new, we have a podcast called The Course, for which we have about 150 interviews with our UChicago faculty. And they talk about how they became professors. So this is a podcast production that we have created, produced, host. It's on all the podcast platforms, so you can find it just about anywhere. The Course. Check out some of our faculty. Maybe one of your faculty from your UChicago days is on there. We'd have to check. But anyway, thank you so much again, Professor Chen, and everybody have a good evening. Thanks for joining us tonight.